When the screen goes dark and the world won't start, you know who to call, yeah. Watching you struggle with that frozen screen. 3 days now and you're losing your mind. I see it tapping but nothing's working right. Daniel's got that look in his eyes. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you're always there? Coffee's getting cold while you run diagnostics, explaining every step like I'd understand. Your hands move fast across the keyboard, magic, making sense of what I can't comprehend. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you always there? Maybe it's not about the broken parts. Maybe it's about the way you see. Every problem has a beating heart. You won't give up on me. Now the screen's alive and everything's running smooth. You pack your tools with that quiet smile. I know tomorrow when something breaks loose, you'll be back here in a little while. That's why you always stay when everyone else walk away. That's why you always care, Dad. That's why you're always there. The screen goes dark and the world won't start. I know who to call, yeah.
Well, welcome to the show. Hello, everybody is coming in. I gotta sneeze. Or do I have to sneeze? Guys, if you like the content that's on this channel, excuse me. If you're not a subscriber to this channel and you like the content that's on this channel, please do me a big favor in subscribing to this channel and helping this channel grow. That's the one way that you can help support the channel, by subscribing. So you guys remember that incompetent lawyer, that lady lawyer that was in front of Judge Simpson for this one landlord-tenant case? But guess what? Our friend is back again in Judge Simpson's court. So let's get this started. So share screen, incompetent lawyer. Go back to StreamYard, make this bigger.
Housing, 401k plan. Good afternoon, Donna Toth. On behalf of Erica and Aaron Ward, they are the tenants in this lease.
All right. Where are we now, folks?
So my understanding is after the long conversation that we had last Monday, that this hearing was held in anticipation of my action or interaction. And I would, if I filed a withdrawal, then the hearing wouldn't be held. And
If you filed it with, I don't think I said that.
well, you didn't say it, no. But you said that if circumstances worked out the way you were suggesting, there were two choices, and that's why this hearing was being held. Do I not have it correct?
I don't know what you have. Keep going.
Okay. So I'm here because I would like to make this statement to the court on the record. This case is a landlord-tenant case. I repeated that in our answer that was filed with this court. The lease is not a commercial lease. As plaintiffs and this mentioned several times, the lease is between an LLC landlord and a married couple, Erica and Aaron Ward. The lease specifically states the lease is for their use as an animal farm. The property is zoned agricultural and has been used lawfully for over 25 years as an equestrian center with several major outbuildings and one residential unit. This lease began in 2021, just 3.5 years ago. The lease terminates in 3.5 years from now. None of the land is zoned commercial. None of the property is used commercially.
Why are you telling me this now?
And the lease is not a commercial lease because several times plaintiff has referred to this as a commercial lease. And I heard this court repeat that this is a commercial lease. There are different standards applied to commercial property and commercial property that is leased.
All right, then all you have to do is say, without this long rendition, that you don't believe it to be a commercial lease.
Okay. Well, I felt I need to just restate what I had said in my answer. It didn't seem to have been heard. I have been associated with Erica Ward.
I hear everything. Now,
Mhm.
whether I react to it becomes a whole different thing, but I hear everything. Go ahead.
Well, I have been associated with Erica Ward for over 3 years in consultation with me as a property manager through my solo-owned property management company. She consulted with me over these past couple of years over many serious, dangerous conditions the landlord had refused to repair. I gave her the City of Ann Arbor information required to be provided to tenants by landlords and the Michigan State University Law Center's information for tenants and landlords, both of which describe the right of the tenant to withhold rent and pay for necessary repairs for the health and safety and habitability of the rented property when the landlord has refused to make the necessary repairs. Our answer filed with this court had the circuit court case attached, which was filed in July 9th of 2025. The jurisdiction for our breach of lease case was with the circuit court. And our answer describes the necessary repairs the landlord refused to make since 2023, which is his duty under the terms of this lease for agriculturally zoned property.
You
Erica
can't
Ward.
have it both ways.
Hmm?
You can't have it both ways. If you're going to claim, so, and counsel, before you go on, I think you need to do your legal research. If you're going to claim that this is not a commercial lease,
Yes,
and it's a 7-year lease,
yes.
then the obligations regarding repair change.
That I think that would be something to bring up by the plaintiffs to rebut what I'm
No.
saying.
Go ahead.
Erica Ward asked me to be her attorney in the middle of July to file a complaint with the court over the landlord's waste and interference with her use of the property, which had caused her damages. This complaint was
Counsel,
filed
I don't know why I need to know all of this.
because, Your Honor, you have questioned my ethical ability
I
to
have not
represent.
requested, I have not. What I have said is that if indeed you took funds that were the landlord's funds, the capacity that you're operating in is going to be a problem, counsel. That is what I indicated. If you don't see it as a problem, then so be it. But I think on its face, it's a problem. Any question regarding your ethics is your own. Because I'll tell you right now, if an attorney comes before me and I think that they have done something that I can show that they have done unethical, you will be reported to the Attorney Grievance Commission in a minute. So I did not do that.
No,
So don't tell me I question your ethics. I question the question. You know what? I don't need the dramatics. Any more dramatics, you're going to be found in contempt. I'm done, Ms. Tope.
Yes. Yes.
What I said to you and what I was indicating is that you took, as you stand before me, the wards are your clients. What I am then told is that you took funds that would have been client funds and somehow took them into your possession to redistribute. Your argument may be that you did it for other reasons.
I would like to state the facts behind the assumptions that I took client funds. I did not. Erica told me that she wanted to, I was consulting with her as a property manager. I was not her attorney.
And if that's your position, that's your position. From the court's perspective, it looks different, which is what I was pointing out.
Yes, and you clear, and
if I want to make an accusation, Ms. Tope, I am not shy. I will clearly make that accusation, and I have not.
You were very clear that it was not an order, it wasn't an opinion, it was words. But I tell you that words have consequences because we are on YouTube.
So does one's actions, Ms.
Yes,
Tope.
yes,
Whether YouTube or not, it doesn't matter. This is a public record.
yes.
And all I am telling you is that the court saw concern.
Yes, and I am here to address the concern so that it's on the record as well, so that.
Ms. Tope, no. I have given my admonition at the last hearing. The wards may proceed in whatever fashion they wish. You may proceed in whatever fashion you wish. If I thought you were doing something unethical, I would myself remove you from the case. I have not done that.
No, right.
So I am done with this issue.
Today. You are done with me today, or?
I am done with that issue.
Okay. Thank you.
Go ahead, sir.
Your Honor, this is the first I'm hearing about a property management company that's holding rent payments. I don't know who the property management company is. I don't know what the bank account is. You ordered tenants to produce an accounting. They did that. It's a mess.
A toddler is considered a late talker if they have fewer.
And my client is the one who's being prejudiced by that. Actions do have consequences, and the consequences of their agent or the actions by tenant's agent have consequences. And they didn't have the right to withhold rent payments. That's what they did. These are grounds for default under the lease. The lease should be terminated, and they have to deal with the consequences. Now, if tenants, they may have their own recourse separate from this action. That's their decision. That should not be with my client, and my client shouldn't have to keep fighting over alleged ethical violations.
They did not have a management agent. She consulted with me about my opinion for over 3 years. I had no jurisdiction over the property. It was completely Erica and Aaron's tenancy, and I was not their attorney.
So,
Was I their property manager?
So,
Yes.
it's those statements which give the court pause. When you're saying that they consulted with you regarding the property, and
Not in my capacity. I was taking writing lessons and she was telling me what was going on, and I gave her some of my advice, but not in a professional or proprietary or
can't do
contractual.
it that way. Okay. All right.
No, as a friend.
Okay.
I think Ms. Hope's property managed company should be a party. She has inserted herself into this litigation. And this went from a simple non-payment of rent and has ballooned because of tenants through their counsel's actions. And it has become a mess.
We filed a circuit court case was filed July 9th, long before this court had jurisdiction. In my first response as their attorney for this court, I asked for an escrow fund to be set up, a trust fund to be set up by the court. And you did that. Anything done before that was not in, there was no money put in any trust fund.
Can I just say, so this, let me just ask this. Counsel, are you
I need to step closer to here.
Are you going, we can get the equipment for it. And so are you going to file a motion to add Ms. Tope and this as a party to this action? I realize I'm asking you on the spot because you're first hearing about it, and I know there would be things to be taken into consideration in doing that.
Obviously, I'd have to discuss with my client. It's something that I would like to avoid. I think the language of the contract is clear that they didn't have the right to withhold payments, and that these are grounds for defaults, and that the lease should be terminated and there should be an eviction order. But if we have to keep going this back and forth way, we may have to. Especially if it's a third party that's handling the rent funds, then we would have to.
Were you the property manager for them?
No,
Were you involved in the payment of funds to contractors?
only in the account that Erica used to withhold her funds. And
What do you mean by that? Who were signatories to that account?
Erica approved all of,
Who were signatories to that account?
I was,
There's our problem.
but not my
Okay,
attorney.
so no. That's our problem. So who else was a signatory to that account?
No one else. Me and me alone. And
Okay, Miss,
the money was filed after we filed the circuit court case.
no, it doesn't matter.
And this court.
Doesn't matter. Doesn't matter. It doesn't matter. Do you not see a potential problem with that, Ms. Tarp? That's a yes or no. If you don't, I don't know what to say.
I see that someone could make an issue out of it. But I don't see a legal problem. So when you say a problem,
Let me ask this,
yes.
since you're given that information.
Get up to 70% off store-wide.
And just think about this for a moment.
Okay.
Whether you believe it to be true or not.
Okay.
Plaintiff claims that the tenants cannot withhold rent in this fashion or make repairs and take that off of the rent. Okay? Tenants do that.
Tenants have done that before they claimed that.
Whoa. Tenants do that. Tenants acknowledge they've done that. And that you are the one that did that on their behalf. Why? What happens given that factual scenario, which I don't think is far from the truth based on what I know, if they file a claim not only against the wards, but also as to you?
I'd have to show why it's not appropriate. Mostly because they were notified that rent would be withheld before it was withheld, and they were notified the bank account that,
So if their claim is you can't do it,
well, I guess,
if their claim is you can't do it,
yes.
then that the wards could not do it. But then you were the one that did it on their behalf. Good, bad, or indifferent. You're the one that did it. Don't you really yourself become a necessary party to this action? And that's what I'm saying. If you're a necessary party, Ms. Tope, you can't be the attorney.
Okay. Okay. I hear what you're saying.
Mr. and Mrs. Ward, do you understand what the court is indicating? I mean, whether you agree with it or not, it's not my issue. You understand what I'm getting at?
Yes.
And so that I'm clear, and what I was trying to be clear at the last hearing was I did not want a circumstance where Ms. Tope, you're brought in as a party and then your clients are left without representation. It's just an issue of the fairness of all proceedings. It doesn't have to do with whether I like somebody or not, or what position I'm taking. So, Ms. Tope, with that understanding, what are we going to do? I don't want to get so far down the line.
We're off track.
For sure.
That what?
We are on this case. We are off track. Get it back centered. I would do whatever's required to be able to deal with the issues at hand and not clog up these proceedings any further.
I don't know what that means.
Well, I'm sorry, that's the only way I can say it.
Your Honor, we're off track due to tenants' agents' conduct by taking actions that were not allowed under the lease in the first place. And this is our third hearing in 3 weeks. And my client is going without any rent payments. He got a partial payment, but he is the one who's being prejudiced by us having to keep coming to court when tenants didn't have a right to do this in the first place. And they have to accept the consequences for their agent's actions.
I was not their agent.
Okay. Then what were you?
I was their friend, and beginning July 9th, I was their attorney in a circuit court case. And they didn't
I
file.
know what, I know what. I'm not gonna go through what you want, what name you want to place on it. Counsel, you know how the terms agent are defined under Michigan law. So the fact that you are somebody's friend does not mean, for the purposes of agency law, that you may not be acting as their agent.
Well, I think that one would have to prove I was acting as an agent rather than a friend in order to put the official together as an agent.
Ms. Tope, I don't even know how that comes out of your mouth. If you're saying that they had money and repairs that needed to be done on property that they lease, they own the property that they're leasing, and that you, whatever name you want to place on it, take funds as the only signatory to an account of theirs and do things with it, reference the property. Pretty much acting as their agent.
I will prepare withdrawal papers and have them sign it. We've talked about this. They're in agreement after this.
Then what? Why don't we start there? Nothing. All right. So you're going to withdraw as counsel?
Yes,
All right. And then, folks, are you in the position right now that you have counsel, or how? No. How much time would it take you folks to get an attorney? What do you think?
I wouldn't know where to start, so I have to look into that.
We typically offer.
Pardon?
You typically suggest.
Well, I don't know. I don't want to bring you back for a hearing and you don't have someone to represent you, but I am about to go into December. December, the escrow is going to have to be paid. So while plaintiff's not getting it, it's going to have to be paid to the court. And escrow was deposited with the court. If you don't know that, it did get deposited.
Your Honor, I received a handwritten note. I couldn't read it, but that's good to hear that they did follow.
A handwritten.
I received a handwritten note that I don't know what.
oh, that was my written request because the court was not available Friday after our hearing. That we went to the clerk to pay the escrow, and we were told that we had to get permission from the court.
To pay it in certified funds as opposed to cash, yes.
They paid it, okay.
And I filed that with the court, and I gave you a copy so that you knew what I had done in order to try to get the amount paid. And they also advised me that since this case is really in 14A4, but they can't take funds here at 14A1.
Yes, they can.
Well, they say that it's put into a bond and it's very complicated, and
I don't care how complicated it is. They can take the money.
well, okay,
They don't have to drive out.
I deposited it.
It doesn't matter.
I like the
Whatever.
drive. It was a nice drive.
Okay. So the 4125 is, my point is that is in escrow.
It has been paid.
And that I have the expectation that the 5,500 will be paid within days of December 1st. All right. So I'm going to give the ward's time to find counsel. So I'm going to adjourn this to December 19th. Allow them to get counsel and allow counsel to, once obtained, to get up to speed on everything that has transpired. Pardon? All right. So I'll adjourn this matter to December 19th, 2025 at 1 p.m. You said?
Yes.
1 p.m.
Your Honor, my client would like to say a few words.
That's fine. Yes, go ahead.
Thank you. Thank you.
I don't really want much in regard to the substance of the case, but go ahead, sir.
Thank you. Your Honor, so my background is I'm a family man with 6 children. This property is our family's entire retirement. I was adopted, worked my way through school, started a mortgage company in 2003 that's operated for 22 years without a single bad review. I've served on the board of the directors for the Arthritis Foundation and Entrepreneurs Organization. I work with the Congressional Medal of Honor Society. I spent over 10 years coaching and sponsoring at-risk youth for football and baseball, including future Maryland running back Nolan Ray. We have saved our entire life to be able to purchase this property. The tenants have been operating a business on it without paying rent. They've made false statements about me, potential future buyers. They've contacted my land contract seller to try and usurp me and purchase my debt. The land contract seller contacted me to alert me immediately and denied them.
People think they know me, but they don't.
They filed a PPO against me. And I haven't even been to my property for close to a year because of how hyper hostile the experiences have been. I won't even take my family there. The PPO was denied immediately. They then sued me in circuit court before my attorney could file for this eviction. This is the 4th hearing over what began as a simple non-payment eviction. They refused to negotiate. Their actions appear intended to harm my family financially. I'm simply trying to protect my property and resolve this properly. Thank you.
Thank you. And to the parties, as soon as the paperwork and the attorneys and the parties are in order, I will expeditiously get this matter to trial if that's where we have to head. I don't have a problem doing that, but I can't set things when things are in such disarray, quite frankly. The 19th, 2025, 1 p.m. Your attorney once you hire them, will know to file. What they're gonna have to do in this case, they're gonna have to file a substitution. Well, actually not. I'll need an order of withdrawal sent. Or just call the case, People versus Jenny Lou.
Good morning, this is Local Winter Warren County on behalf of Ms. Lou. Ms. Lou, please state your name. Jenny Lou.
All right, thank you.
And we do have a resolution in the case. It does require 3 different cases to be put out. So I'm not sure if we're just gonna do the one today that's up, and the other one at a later time. And Ms. Kearney is nodding, so I think that's the plan is today. So as to this case, she'll be pleading this charge.
The other 2 cases are set for PCC before Your Honor on the 24th.
Okay. All right, so she wants to enter the plea in this one.
Yes, Ms. Lou, do you want to put the offer on the record, or do you want me to?
So in this case, the offer is to plead this charge, the counts of assault and battery. Just all the notes to make sure I get it correct. In case 24F10014, which is prisoner possession of a weapon, that case will be dismissed. 23F10628, assault of a prison employee. She will.
Go ahead.
Thank you. Thought it was an attempt R&O. So we had come to, is my understanding.
So in the felony cases, though, there are 2 of those, but one, ultimately, it will be a plea to attempted misdemeanor attempted R&O.
I believe so, Your Honor. I'll double check while we work on the plea for this case, but that was my understanding.
That's what I had in my notes as well. And then one would be dismissed. And then.
Ultimate, right, ultimately, she's pleading to 3 misdemeanor charges,
That's correct.
right?
And I believe she'll be coming to this court for sentencing.
Okay, in the other matter.
In the other matter, and this matter as well as the court.
Okay,
Thank you.
all right, real good. All right, Ms. Lou, is that your understanding?
Yes, sir.
All right, hold on one moment.
Wait, what?
Ms. Lou, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help God?
Yes, sir.
All right, state your name again for the record.
Jenny Lou.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to 2 charges of assault and or assault and battery. Those are misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs. The court does have to advise you that if these assaults took place in a place of confinement, that consecutive sentence may be imposed. Do you understand that?
Yes, I understand.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, sir.
All right. To the charge of assault and battery contained in count 1, how do you plead?
Guilty.
To that same charge as contained in count 2, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you. You're also giving up your right to remain silent and not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, I understand that.
Are you on probation or parole?
No.
You're not. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you're guilty of these offenses?
Yes, Your Honor.
August 1st, 2023, at the location of the Huron Valley Correctional Facility in Pittsfield Township, Washtenaw County, State of Michigan. What did you do regarding a Misty, what we saw, and Alicia Cargill that makes you think that you're guilty of these offenses?
I had hit one of them. One of them was my girlfriend, and I got into it with her. Then I ended up hitting the other girl, the girl that she was cheating on me with. And so, yes, I'm guilty for that.
Okay, so you ended up hitting them both?
Yes, sir.
You didn't have their permission to do that, did you?
No, not.
And you
no.
did it, and you did it intentionally?
Yes, sir.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas? Court will accept the defendant's pleas of guilty to counts 1 and 2. Pre-sentence investigation and report is ordered. Sentencing in this matter will be. When is she up on her?
April 24th, sir, Valleys. Yes.
Yeah, I want the next one.
The 14th at 9 a.m.
Sentencing May 14th, 2025, 9 a.m. Bond in these matters will continue. Thank you, Ms. Lou. Let me, Ms. Lou, hold on one moment, Ms. Lou.
Okay.
Yeah, let's do that. We're gonna just stay on the line. We're gonna put you into a breakout room with probation intake so they can start the process, okay?
All right.
All right, thank you.
Thank you.
Thank you. Court does call the case of the people versus Salvador Barrentes.
Right, good morning, Joe Simon on behalf of the Salvador Barrentes, Your Honor.
Thank you, sir.
Sir, I do believe we reached a resolution in this matter.
Yes.
Exchange for fees when added count 2 of operating while intoxicated, operating while visibly impaired. First offense, the 93-day misdemeanor, $300 fine and various license restrictions contrary to 2576253A. And an agreement to pay restitution in the amount of $1,425. Count 1, operating while intoxicated, will be dismissed.
All of that is accurate, Your Honor. Mr. Brian, I just filled out a advice of rights from the church.
All right. I have it. May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony about to give the truth, the whole truth, without question. So, yes, I do. State your name. Salvador Barrentes, Jr., Your Honor.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order rehabilitative services or any community care service the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do, Your Honor.
And understanding that, you still wish to plead guilty.
I do, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today, is that correct?
That's correct, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights.
I do, Your Honor.
You understand you're giving up your right to appeal outright.
I do, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
I am, Your Honor.
of your own free will
Yes,
and because you believe that you're guilty of this offense?
Yes, Your Honor.
July 21st, 2024, at the location of on Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
I did, Your Honor.
What do you have and how much?
When I recall, Your Honor, I had at least 3 beers, at least 1 shot of whiskey.
All right. Were you stopped by the police or was there an accident?
I was stopped, Your Honor, due to a thing that was happening incident, and I was backing up, and that's when I heard the tail of our side mirrors hit.
During the defendant drove up to a scene where police had made a stop, and there was a police incident going on, and then attempted to perform a U-turn and hit another vehicle that was parked. And then police made contact.
All right. Is that correct, sir?
That is your honor.
All right. Were you ultimately arrested?
Yes, your honor.
All right. Were you taken to the hospital?
I was, your honor.
Was there a blood draw?
Yes, your honor.
And were the results of that blood draw 0.128?
Yes, your honor.
All right. Do you have any reason to dispute those blood test results?
I do not, your honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, your honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant,
Variances has been screened and assessed and completed by Ms. Geiger, if that helps the court in the sense, and it does that.
At Bay Fortis, we know babies are full of surprises, but
no, no. If you provide that to Ms. Parody, then we can, but I will refer him, I'll refer him to Von Suarez for an alcohol screening and assessment and the victim's impact panel. What? Ms. Parody, did I?
I'm just opting present.
So you give it to her and then you give it to Ms. Polero.
I can't.
All right. Sentencing in this matter will be
April 30th to 12 p.m.
April 30th, 2025. 12?
Yes.
12 noon. Bond with its conditions.
Thank you.
I would never.
You're a wise man. All right. I wish I could say the same for people around me. Emily. Court calls the case, People versus Gabriel Boyd.
Good morning, Judge. I get spotted on behalf of Ms. Gabrielle Boyd, is here because we just named for a lot of my clients.
All right, ma'am, can you state your name, please?
Gabrielle Boyd.
Thank you. All right, what are we doing?
Thank you. Today, they have set up for short. I respectfully just ask for one more adjournment, Judge. I did have the videos. I do have the police report as well. I just need some time to go over the videos with my client and obviously for the negotiations to start. Judge, if that's possible. I know the 2 dates were offered April 23rd, I believe, and May 7th. I will respectfully requesting May 7th. Client's schedule with work, I think Judge, you're aware of it. It's pretty hectic, especially on Wednesdays, and this month is particularly difficult for her. So just to accommodate, Judge, if at all possible, my client.
Any objection from the people?
There you go.
Adjourn the matter, May 7th, 2025, 9 a.m. Bond continued.
And also for the record, I would never.
Wow.
I'm learning.
Yeah. You're learning from Mr. No,
No.
you don't want to do that. We'll point you to the people that didn't help yet. Thank you. Court calls the case, People versus Michael Klostra.
Dallas with on behalf of Michael Lustra.
All right, thank you.
That's correct, Your Honor. Defense counsel providing us additional information they wish me to consider. In this case, I need more time to look into that. It's a little complicated. I could get confirmation of that first, but then ultimately I'm looking at for the late April date.
All right. Adjourn the matter, April 23rd, 2025, 9 a.m. Bond will continue.
We have
Thank
one request. Mr. Lustra is efficient walleye season. He's asking to go to Ohio for walleye.
He's going to Ohio on purpose.
Yes, but it's
Is that where
little to people, it's more about.
the walleyes? That's where they hang out? We don't have walleye in Michigan?
I like Ohio.
Oh, wow. You hear how he said that? I should take offense. When does he want to travel to do that? The whole month?
Fine. Season, so.
So you want to travel during the month of,
April from now to April.
do you have any problem with him traveling to Ohio to kill walleye?
No, you're right.
All right. Defendant may travel to Ohio. Thank you. Shouldn't have put it that way. It's not like murder. Court calls the case, People versus Sarah Orr.
After long for the people.
Sarah Foster Tucker on behalf of Sarah Orr.
Sarah Orr.
Thank you.
And Your Honor, we're just asking for an adjournment. Ms. Lonnie and I did discuss this case. I think Ms. Lonnie just needs to look into some additional information.
That's correct. So there's been an offer, a request for the offer. I need to talk with them about.
April 23rd work for us.
It's fine.
April 23rd, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you.
Thank you. Thank you. Court does call the case of the People versus Angela Walker.
After long for the people.
Carolyn Foster Tucker on behalf of Angela Walker. Angela Walker.
Thank you.
And Your Honor, Ms. Lonnie and I have been discussing this case. Unfortunately, we have not reached a resolution yet. We're hoping to just set this for a final settlement conference. Hopefully we can resolve it ahead of time.
Your offer has been extended, actually two versions of an offer to let the defendant choose which she prefers has been extended to the defendant. I understand she doesn't want to accept either at this time. I'm willing to leave that open to the final settlement date. Because this is an OWI, and I believe it was a blood draw case, it's lots of folks to get together. I was going to request June date since our next final settlement is next Friday.
And there's no objection.
Jury final settlement conference will be June
6th at 9 a.m.
Is that right?
That's what's up in the calendar.
Okay, I figured you just didn't pick it, but I'm thinking it's, you know what? I'm not talking to Emily anymore. And
That is an accurate statement.
which part? The part about Emily or part about the day?
Yes.
That's the, okay, the only reason I'm saying is that's the first Friday and not the second.
Correct, which would make jury selection on Monday the 9th, and that's when the other judges are also doing their jury selection.
That's a long confirmation. It just, June 6, 2025, 9 a.m. Jury selection, if necessary, June 9, 2025 at 8:30. Both of those proceedings are in person. Bond with its conditions will continue.
Thank you, Your Honor.
All right, thank you. Court does call the case of the People versus, is it Diaware? Yeah, Diem.
Good morning, Your Honor. Paul Tefelsky on behalf of Ms. Thiem.
Looking for a remand and retrial, Your Honor.
State your name, ma'am.
The digital world. It's where business gets done.
Hello?
Yeah, hello.
Yes.
Can you state your name, please?
Yeah, Rachel.
Did she say it?
She did.
All right. I didn't hear her last name, but that's her. All right. Counsel, she's here for arraignment and pretrial as to the arraignment, waive formal reading of client stands mute.
Yes, Your Honor.
Defendant have waive formal reading standing mute. Court will enter a not guilty plea as to both counts. Or what are we going to do? This.
Your Honor, I did receive the police report. This is a 2020 case. My client just recently learned about it, and she did turn herself in and post a bond, I believe. And I haven't had the chance to talk to the prosecutor yet or to receive the videotapes from the incident. So I would ask for an adjournment for discovery, and that date that you've been using, April 23rd at 9 a.m. would work for me. It works for the court.
During the pretrial will be set for April 23rd, 2025, 9 a.m. I'll set the defendant's bond, $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. Also, there's to be no possession or consumption of alcohol, recreational marijuana, or any illegal drug. I'm further going to indicate the defendant is not to enter any Costco in the state of Michigan.
Thank you, Your Honor.
Thank you. See you on the 23rd.
Bye-bye.
Calls the cases of the people versus Jason Allen.
Actually, one of the people in all matters.
7, 8, 9. All 9 of them.
Public defenders on behalf of Jason Allen, who appears to be a Zoom Don Farm. Sir, can you please state your name for the record?
Jason Allen.
Thank you.
Thank you, Your Honor. I have discussed these matters with both people and Mr. Allen. Ultimately, we're requesting a lengthy adjournment, possibly 4 to 6 weeks if the court would allow that. Mr. Allen is needs to track his progress both in the drug treatment court as well as treatment and dog farm.
You want something beyond May 7th?
If possible, Your Honor. Safely first. That would be great.
That objection, all these matters adjourned May 21st, 2025, 9 a.m.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Allen.
Thank you.
Thank you, sir.
Case people versus Zachary Burlett.
Public defender Natalie Page, but not even watch Mr. Left to appear to be at Zoom. Sir, can you unmute and state your name for the court?
Zachary Burlett.
Thank you.
Thank you, Your Honor. Just late last week, I was able to provide the people with some documentation as well as some mitigation information that I believe they would probably still be reviewing. I would ask for a brief adjournment then to review it and discuss it further with the people. That's correct, Your Honor.
Adjourn this matter April 23rd, 2025, 9 a.m. Bond continued.
Thank you,
Your Honor.
Thank you, Mr. Burlett.
Court calls
Thank
the
you.
case of people versus Nicole Caldwell.
Assistant Public Defender Natalie Page, but not the applicant, Mrs. Caldwell, who appears to be at Zoom. Ma'am, can you please unmute and state your name for the record?
Nicole Caldwell.
Thank you, Your Honor. I was able to review discovery in this case and partially review it with my client. I'm asking for an adjournment to further discuss that with her in next steps.
Without objection, April 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Court does call the case people versus Billy Cobb Gully.
People, Assistant Public Defender Natalie Page, but not Mr. Capelli, who appears to be at Zoom. Sir, can you please unmute and state your name for the court?
Billy Cobb Gully.
Thank you.
Thank you, Your Honor. I have discussed this matter both with my client and the people. And this, as Your Honor is aware, Mr. Codbelly was hospitalized in his last pre-trial. We're asking for an adjournment in order for him to earn the plea reduction requested.
May 7th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, sir. We'll be in touch.
Court does call the case of the people versus Ashton Ebler.
Assistant Public Defender Natalie Page, on behalf of Mr. Eastman, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Ashton Ebler.
Thank you.
Thank you, Your Honor. I'm respectfully requesting a very brief adjournment so that Mr. Ebler can obtain proof of the vehicle sale at issue. That's correct, Your Honor.
April 23rd, 2025, 9 a.m. Bond will continue.
Thank you.
All right, thank you.
Thank you, sir.
Madam Interpreter, can you please unmute and raise your right hand to be sworn?
I don't know if she
Can
does.
you please unmute, Madam Interpreter, and raise your right hand to be sworn? Can you hear me, Madam Interpreter?
Hi, I'm having a hard time listening, understanding.
Can you please raise your right hand to be sworn?
Okay.
Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Portuguese and Portuguese into English in the manner now before the court, so help you God?
I do.
Thank you.
Good morning, Madam Interpreter. Court does call the case of the People versus Maxwell Costa.
Corte está chamando o caso das pessoas contra Maxwell Costa.
Ashley Londy for the people.
She didn't hear that. It's Ashley Landy for the People.
Ashley Lande representando o povo.
Assistant Public Defender Lauren Perry on behalf of the defendant.
Eu sou a Lori e eu sou a advogada de defesa do acusado.
Maxwell Silva Costa.
I'm sorry, I couldn't hear.
He said his name, Maxwell Silva Costa.
Meu nome é Maxwell Silva Costa.
Your Honor, we're asking to set this for final settlement conference, please.
She said she's asked, it's all right, that she's asking that this be set for final settlement conference.
Eu gostaria de pedir para que isso seja enviado para a decisão final.
Jury final settlement conference will be set for April 11th, 2025, 9 a.m.
Nós vamos combinar para que a decisão final seja no dia 11 de abril de 2025, às 9 horas da manhã.
Jury selection, if necessary, will be April 14th, 2025 at 8:30.
Se nós precisarmos selecionar jurados, isso será feito no dia 14 de abril de 2025, às 8:30 da manhã.
Both of those proceedings are in person.
As duas audiências serão feitas pessoalmente.
Bond will continue.
A fiança continuará sobre a mesma cautela.
Thank you. Thank you, Madam Interpreter.
Okay, thank you. Appreciate it. Have a great day.
You too. Court does call the case. People versus, is it Rogaya Awasi?
Regardless.
All right.
Thanks, Your Honor. We have reached a resolution in this matter.
Your Honor, there was an offer extended to the defendant to plead to an attempt to operating while intoxicated, first offense, a 93-day misdemeanor, $100 to $500 fine, various license sanctions, contrary to MCL 25762.
I'm sorry, can you start that again?
I'm sorry. So she's going to be pleading to an added count 2 of operating while intoxicated, 93-day misdemeanor, $100 to $500 fine, all the different license sanctions. Contrary to MCL 2576251A, in exchange for a plea to the added count 2, count 1, operating with a high EAC, the 108-day misdemeanor will be dismissed.
Is that a correct statement, Counsel?
That is correct.
Has she signed an advice of rights?
Working on that right now. Judge. Let's get that speaking.
Throw it as hard as you want. Go on. Watching it zip away feels like it might just keep going.
And Your Honor, I do understand it will be a no contest plea, so I'm saying that police report now.
Well, then I'm going to pass it because I'm going to have to review the report. I'll pass it. Court does call the case. People versus Kyle Burmeister.
That's one of the people. Public defender Natalie Duke, with Mr. Burmeister, who's the first statement to the record, sir.
Thank you.
Thank you, Your Honor. I respectfully request an adjournment. Mr. Burmeister is not being held on this case. Your Honor, for probable cause conference, my understanding is that case, he's represented by counsel. All that being said, I do believe this is a case that ultimately will be resolved. Ms. Lonnie and I have been discussing it. We do not have a resolution in place yet. However, I'm asking for a very brief.
When is his, other,
PCC is tomorrow. That's correct, Your Honor. Yes, Mr. Vitalski, on that case, he was remanded a couple weeks ago, I think, for me to recall.
yes, I do recall. All right. During the matter, April 23rd, 2025, 9 a.m. Bond in this case will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Natasha Olmos.
People.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Mr. Silver.
Robert Alden got on this almost a case ending in 0092.
Assistant Public Defender, on behalf of Ms. Olmos, the case ending in 1426.
Your name?
Natasha.
Thank you.
This one, in this case, my client, Ms. Olmos, is going to be accepting an offer that Mr. Siller had extended, in which case the misdemeanor will be dismissed, and she would accept responsibility to double parking the civil infraction.
That's correct. Township case.
Under 1426.
Correct.
All right. And on the other matter, what are we doing?
We're asking for an adjournment, Judge.
All right. So in case ending in 9/2, I'll adjourn that matter to April 23rd, 2025, 9 a.m. Her bond will continue in that case. In the other matter, ma'am, do you admit responsibility to the fact that on or about October 27th, 2024, at the location of Gulfside Road near Twin Lakes in Pittsfield Township, Washtenaw County, State of Michigan, that you double parked the motor vehicle? All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can you pay that, man?
You're asking for the end of the month, Your Honor. She just recently started a new job.
Do you think you can get it done by then? Okay. Pay it by April 30th, 2025. Thank you. Court calls the case of the People versus Sean Charnley.
Conrad Silver on behalf of Pittsfield Township.
2 cases.
Good morning. Public Defender Secretary of the House and Search Charlie. Please state your name, sir. Now, we're asking for, not lengthy adjournments on these cases. He's being held on felony cases. He wants to resolve those before, there's 2 hearings on those before resolving.
Trying to resolve this, okay.
Yeah, he doesn't expect to be released anytime soon.
Okay, so when's the next hearing on this felony cases? Okay, so okay. Are you, and I know you don't know the answer to this necessarily, are you expecting that they'll be resolved tomorrow, or that something's gonna have to happen after that? Okay.
I hope that it do go tomorrow.
Right, okay. Why don't I do this then, since I'll adjourn these out to May 7th, 2025, 9 a.m. I'm not sure what scheduling you'll be working up in circuit court. If it needs, for whatever reason, since he's in custody, if those resolve in a way that he's out of custody and he's still in on these, then just let us know. We'll move his date up.
Can I maybe approach?
Yes. All right, I'll adjourn this to the May 7th, 2025, 9 a.m. All right, bond continued. Thank you. Court calls case People versus Frederick Warden.
Conrad Silver on behalf of Pittsfield Township.
Good morning, this is Senator Ron Attorney on behalf of Mr. Warden. Mr. Warden, could you please unmute and state your name?
Hi, Bella.
Frederick Worden.
Thank you.
Yeah, Ms. Blondie and I, regarding the, driving case, we did speak regarding a resolution today. I'm just asking for a brief adjournment so I can, relay the offer to my client and discuss any potential penalties. And I just asked for the Pittsfield case to tag along with that, please.
That was a long way of saying you want an adjournment. April 23rd, 2025, 9 a.m.
Thank you for summarizing.
Well, no.
Thank you.
No. Because people versus Jacob Dorson.
Township. Good morning, Assistant Public Defender Mark Haney on behalf of Mr. Dorston. Mr. Dorston, please state your name for the record.
Jacob John Dorsey.
Your Honor, Mr. Dorston's complete no contest as charged.
As charged.
Yes.
Have a report one. I do. Because he signed in advice of right. No. So I'll wait for that. While you do that.
For the record, Your Honor, the no contest plea is for lack of recollection.
All right. So he's pleading no contest as charged.
Yes.
And have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God. Yes. What's your name?
Jacob John Dorsey.
Sir, it is this court's understanding that you're to plead no contest to the charge of disorderly person under the Pittsfield Township ordinance. Is that correct?
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 90 days jail, $500 fine plus court costs. You understand that?
Yes, Your
All right. Do you understand what a no contest plea is?
Yes, Your
All right. Two things about it I have to make sure that you understand. First thing you need to understand is that it first of all means that you're not desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Still wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form today. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? Doing this voluntarily
Yes.
and of your own free will?
Yes.
All right, the court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25950. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea of no contest to this charge. Is he being held on anything? I don't.
He is, Your Honor, resisting an obstructing case scheduled for this court tomorrow. I asked for immediate sentencing to time served, Your Honor. I believe it's been in for almost a month. 25 days.
Any objection to that on behalf of the people?
No objection.
Sir, is there anything you want to say before I do impose sentence?
Yes, I just want to apologize to you and everybody involved in the case. I'm sorry.
Okay. I'll impose the state minimum fines and costs $125. And then 25 days in jail, credit 25, sir. Thank you. Court does call the case of People versus Jessica Fox.
That's a lot of.
Your connections to the past are
She here. Is she representing? Oh. Ms. Fox?
Put in the chat room, and she's not even.
She can't hear us, we can't hear her. So, Ms. Fox, can you hear us? If you can, wave your hand. She can hear us. We cannot hear you, however. It's okay, don't panic. You're- All right, Ms. Fox, why don't you do this? Hold on. Why don't you?
Sorry.
What were you doing?
I'm trying to plug in my computer.
That loudly? Never mind. Ms. Fox, why don't you sign out and sign back in? I'll pass your case and we'll see if that'll work for you, okay? Court calls case People versus Matthew Giddens.
Hunter and Silver on Catholic, Stewart Township.
Mr. Public Defender, Deputy right, state your name, for the record, sir.
Matthew Giddens.
All right, thank you.
Thank you, Your Honor. There is a resolution in this case to which my client will be pleading no contest as charged.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God. That's it. State your name.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of possession of drug paraphernalia. All right. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yeah.
All right. Basis for the no contest.
Such as liability, Your Honor.
Do you understand what a no contest plea is? All right. Two things about it. I have to make sure you understand. It means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. Still wish to plead no contest? And to that charge, how do you plead? Now you understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form today, is that correct? Any question regarding any of those rights? Please look at paragraph 5. You see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights in that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? All right, were you on probation or parole time of this offense? Okay. You understand then your plea could be a violation of that probation. You understand that as such, if it is considered a violation, that court could sentence you to the maximum allowable under that charge. Under that other charge. You understand that, sir? Really, Farroney?
I know.
Really? No, sir. Has anybody promised you anything other than what's promised you anything at all to get you to plead no contest? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will. All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 245474. Any objections to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea of no contest to this charge. Is he being held in anything?
He is, Your Honor. He's set for sentencing at the end of this month on his 2 pending felony cases. It's my understanding there is a sentencing agreement in place
He has 56 days credit. I'm asking for,
56 days on this case?
yes, he's been in.
All right, any objection to immediate sentence? Anything you want to say before I impose sentence, sir? Fines and costs of 125, just do state minimums. And you've been in 56 on this case? 56 days, Washington County Jail, credit 56 there. All right. Thank you. Court calls case People versus Chiffon Hayes.
I'm
here.
Good morning, this is the Public Defender Mark Perry on behalf of Ms. Hayes. Ms. Hayes, please state your name for the record.
Chiffon Hayes.
Thank you.
The arrest is subject to counsel.
Jury final settlement conference will be April 11th, 2025, 9 a.m.
Okay.
Jury selection, April 14th, 2025 at 8:30. Both of those proceedings, ma'am, are in person. Okay?
Okay.
Bond will continue. Thank you.
Thank you.
Court does call the case of the People versus Yusuf Jama.
So I'm getting this to township.
Assistant Public Defender Natalie Hayes, with that be one, who's a please state your name.
John.
All right, thank you.
Thank you, Your Honor. I'm also requesting a very brief adjournment so that I can to get the treatment verification for Mark the clinic that my client is receiving treatment. He's not being held in this case.
All right. During the matter, April 23rd, will that be enough time for you to?
I believe so, Your Honor.
All right, April 23rd, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you.
You're welcome, sir. Trying my patience. Court calls case People versus Alicia Stewart.
Public Defender Natalie Hayes, on behalf of Ms. Stewart, who should be present via Zoom. Ma'am, can you please unmute and state your name for the record?
I got you. Alicia Stewart. There's somebody that has signed on as iPhone 1. Can you unmute and give us your name? Hello, what's your name?
Shantae Johnson.
Okay. All right. We'll mute you back, but I don't have Miss Stewart.
Your Honor, I did expect her here today. I don't have an explanation for.
I expect them all to be here.
Communication with me. She has a Secretary of State hearing that she finally got a hearing date scheduled for May 1st. We were going to be requesting an adjournment. For the record, I would request an adjournment after that date. I don't have a further explanation for failure to appear. I expect her to be here.
Bench warrant will issue for defendant's failure to appear. Bond will be set amount of 5,000. I'll give a 10% privilege. That warrant will issue. Well, what's today? The 2nd.
Yes.
Give me time to try to find her. I won't issue the warrant until April 4th,
Thank you, Your Honor.
2025. Court calls the cases of the people versus Christopher Minor.
Ashley Lonnie for the people.
Conrad Silver on behalf of Pittsfield Township.
3 cases. Is that Mr. Minor or no?
Mr. Pinkston.
No. Court calls the case of the people versus Joseph Pinkston.
People. This is public defender Natalie Tate, this is not the cast, this is Kingston, who stands to my right, please state your name for the record, sir. Thank you, Your Honor. There is a resolution in this matter to which my client will be pleading no contest to add in count 2 of retail fraud third degree and exchange count 1 of retail fraud second degree would be dismissed. That's correct, Your Honor. Retail fraud in the third degree being a 93 days of year, $500 fine or trouble amount, contrary to MCL 750356 ES and Delta 4.
Is he signed in advice or rights form?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear in front of the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Sir, it is this court's understanding that you are going to be pleading guilty to the pleading no contest, I should say, to the charge of retail fraud in the third degree. Is that correct?
Yes.
Okay, that is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that? All right. Do you understand what a no contest plea is? 2 things about it. I have to make sure you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. Basis for no contest plea? To that charge, sir, how do you plead?
No contest.
Okay. You understand that by pleading no contest, you will not have a trial of any kind? All right. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of rights. Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will? All right, court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2413961. Any objections to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
People are satisfied. Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be April 30th, 2025, 12 noon. Bond will continue. Thank you. Court does call the case of the people versus Jada Taylor.
People. Good morning. This is Public Defender Lauren Horning on behalf of Ms. Taylor. Ms. Taylor, please state your name for the record.
Hi, Jada Taylor.
We're requesting an adjournment. Ms. Taylor and I just need some time to review the media together.
That objection, April 23rd, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Wait, what's this box?
Remember that survey I filled out? They actually
Court does call the case of the people versus Caleb Whaley.
People. Good morning. This is the Public Defender Lauren Horning on behalf of Mr. Whaley. Mr. Whaley, please state your name for the record.
Caleb Whaley.
Okay, thank you.
Your Honor, we have come to resolution for a civil infraction. Mr. Whaley, is that what you want to do today?
Yes.
Double park.
No, you're on the
Oh,
office.
I'm sorry.
To an added count, or to be responsible, not guilty, to an added count of no proof of insurance, contrary to 2573281.
That's one.
150.
All right, Mr. Whaley?
Yes.
Sir, do you admit responsibility to the fact that on or about January 26, 2025, location in Pittsfield Township, that you, upon the request of a police officer, failed to provide proof of insurance?
Yes.
All right, court will accept that admission of responsible. To that count two, count one is dismissed. Fines and cost of $155. When can you pay that?
I would need time.
Okay. Like how much time?
4 months?
Excuse me?
4 months? I know I'm in Albuquerque right now, but I'm currently homeless right now. I'm staying on it.
Okay.
I do know,
Did you talk to him about that?
I do know that he's going through some financial difficulties, Your Honor. Maybe we could do 6 weeks and, if he makes some payments, we can extend that period, if he hasn't paid it off by then.
May 31st, 2025. All right, thank you. Barney is up to something today. I don't know. Court does call the case People versus Jared Roberson.
Special ones for people.
Gerald Roberson? No response unless you're in order to show cause. Failure to. Oh, hello, your name? You're not Jared Roberson. Jared Roberson. All right, come on now. State your name for the record, sir. Okay. Sir, you are before the court on a misdemeanor complaint that alleges that you are operating a motor vehicle with no insurance under the motor vehicle code. Do you understand that, sir? All right. It's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that? All right. First question I have for you, and I should say, this is alleged to have occurred on March 6, 2025 at the location of eastbound I-94 near Stone School Road. It alleged to have occurred on eastbound I-94 near Stone School. All right. All right, sir. First question I have for you is, do you want to be represented by an attorney? No? What are you going to do in this case? Okay. Is that really what you want to do? Really? What if it could be worked out to something less than a misdemeanor? Are you having problems hearing me? Yeah. Yeah, okay, we've got equipment. Let's see if that'll work for you, okay? Does that help you at all, sir? Yeah. Oh, okay, all right. So next time you come in, just make sure to ask us for that, okay?
Hello?
So, seriously. Does Ms. Fox, she's here? Okay, tell her away. All right. You don't want to be represented by an attorney? What if something can be worked out that's not a misdemeanor? Wouldn't you like to explore that option? Yeah. So do you know how to do that? So do you want an attorney to help you? Yes. Great. Public defender Katie.
Public Defender Natalie Page is not stands by right, we would waive any further reading, stand mute, and ask for a pretrial date.
Defendant having waived for a reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to April 23rd, 2025, 9 a.m. Bond in this case will be $5,000 personal recognizance bond, standard conditions, no assaultive behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. Thank you.
Thank you, Your Honor.
Court calls the case of People versus Daniel Sims. Saturday.
That's a lot of people. Sorry about that, Your Honor.
It's okay.
Assistant Public Defender Natalie Page with on behalf of Mr. Sims, who stands to my right. Please state your name for the record, sir.
Daniel Sims.
Thank you.
Thank you, Your Honor. I have discussed this matter both with my client and people. We're asking for a very brief adjournment to get the CCTV footage out from the store.
Got it. Is he being held on anything else?
He is, Your Honor.
All right. So I'll adjourn the matter to April 23rd, 2025, 9 a.m. All right. Bond will continue. Well, hold on.
You might have a PR on this, Your Honor.
Does he want a PR? I mean, he's.
If you have someone next time, I'm waiting to go to see you.
Yeah.
Oh, and the other. Oh, gotcha. All right. We'll leave it at PR. All right. Thank you, sir. Let me try this. Court recalls the case People versus Jessica Fox.
Absolutely, but people.
Can you hear me?
Yes, we can. Cannot see you, but we can hear you.
When I tried
All
to
right.
click the video, but did you see me?
No.
Okay. I'm not sure.
We
how to
can
do
hear
this.
you, can't see you.
Okay. Do you need to see me?
Yes. Because I
Okay.
got to arraign you.
Everything's on. I'm using my. Okay.
Well, last time we could see you but couldn't hear you. And now we have the opposite problem.
Yeah. I'm trying to get. Oh, there it goes, maybe.
Okay.
Start.
Oh, you're there now. Well, your keyboard is.
Okay.
There you go. I think we have you. State your name.
Jessica Fox.
Okay, Ms. Fox, you are before the court on a misdemeanor complaint that alleges that on or about June 3rd, 2018, at the location of 2380 Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you did commit the offense of child abuse in the 4th degree. Do you understand the nature of that charge, ma'am?
Not really, no.
Okay. Specifically, that charge alleges that on that date and at that location, that you did knowingly or intentionally commit the following act or acts under the circumstances posed, and that under those circumstances posed an unreasonable risk of harm or physical injury to a child by failing to supervise or attend to a minor. Do you understand the nature of those charges, ma'am?
Yeah.
All
Yes,
right.
I'm sorry.
That is a misdemeanor punishable by 1 year incarceration or probation up to 5 years. You understand that, ma'am?
Yes.
All right. First question that I have for you, ma'am, is do you want to be represented by an attorney?
Yes.
This is a public defender case.
Good morning, Assistant Public Defender Mark, attorney on behalf of Fox Group, wait further reading, schedule for charges, request another pretrial date and a personal bond.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
Can I ask a question?
Yes, you can. I don't want you to ask anything about the case, but go ahead and ask. What's
Okay,
your question?
Then nope, it's about the case, so never mind.
Okay, so you have an attorney now, the public defender's office. So any questions you have in that regard, you can direct toward them, okay?
Feeling under the weather?
So I'm in Pennsylvania, and I know that you guys are in Michigan, so I'm not sure how to contact you, the public defender.
Okay, well, let me get through this part. Standing mute, pleading not guilty. I'll set her bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of weapons. I'll order no alcohol, recreational marijuana, or any illegal drug. Yes, Ms. Lundy.
Your Honor, may people be heard on?
Go ahead.
Your Honor, this is a case from 2018, and I recognize that it's quite some time ago now. However, the allegations include the defendant being unconscious as a result of alcohol consumption and a 4-year-old child becoming outside the hotel when they were asked for the police to come. I'm very concerned about alcohol for this defendant. I'm hoping things have changed for her, and perhaps it's no longer an issue, but at the time, the PBTs were all above 0.2. There were 3 different PBTs given, initially 0.223, 0.238, 0.218. A open bottle of alcohol was located by the police in the hotel room, was seen to be in one location. During the investigation, it was discovered that the bottle was no longer there. It had been moved and more alcohol had been drank from it. Another PBT was given to the defendant, which indicated an increased PBT of 0.31 at that time. So I'm very concerned about her ability to control alcohol. I understand she is now in Pennsylvania, and it may be difficult for or possible for her to get to community corrections, but the people are requesting some sort of alcohol monitoring or intermittent testing of some kind. Thank you.
I just completed, I've been sober for 4 years now. I was in an air program that's down here. Like I haven't touched a drop of alcohol or haven't failed a drug test or anything in over 4 years.
Okay, so go ahead.
I was just gonna ask, are you testing or have you been testing? And can you get those records?
I can get the records. I just quit doing all of this stuff. I just wanted to be done with everything 2 months ago, and then I started my therapy. But I was in the program for over 4 years.
Okay, so here's what I'm gonna do. I'm just gonna order that there's to be no possession or consumption of any alcohol. However, I'll give you an opportunity to get that information for Ms. Fox to get that to the public defender's office, and then for you to get that to the prosecutor. We can address this at the next hearing. Okay. So I will adjourn. The pretrial in this matter will be April 23rd, 2025, 9 a.m. as your invite indicates. I won't order any additional testing at this point. I just order the standard conditions and no alcohol, recreational marijuana, or any illegal drug. Okay, ma'am?
Absolutely.
I will. So do you now reside in Pennsylvania?
Yeah, so I moved here about a week after the incident happened.
Okay.
And I've been here since. So that's
so-
why I guess I had missed the stuff.
Gotcha. What I'll do is I'll indicate defendant may reside in Pennsylvania. Okay. And so I'll leave that at that. Now, ma'am, if you have to get through to the public defender's office, you got something to write with or something to take this down?
Yeah. Yep.
Okay, that's area code 734-222-6970.
I really appreciate that.
Okay, call them, make sure to give them your name that you were at this court, but give them your name, get a valid phone number, a good phone number, as well as an email address. Okay? All right, we'll see you on the 23rd. Thank you, Ms. Fox.
Thank you. Bye-bye.
Court does call the case, People versus Shane Young.
It's allowed. Yeah, this will sound good.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Young. Mr. Astley, statement of record.
Thank you.
So, Your Honor, I know last time we said we could get this resolved by today.
You
but
did.
We did not, but we're very close.
But Ms. Parity,
We.
your day is not going well. But go ahead.
Well, it's always great to see you. We made an agreement with Mr. Siller that if he has a felony and a separate exam on Tuesday. If that case is reduced to a misdemeanor, which we believe that it will be, we'll be pleading on that case, as well as get Mr. Siller proof of why he had these items in his possession. He will dismiss both cases. So
Got it.
we have an agreement. It's just he's got.
You gotta have the exam.
Correct.
And when is it up?
The 8th.
The 8th, before who?
Judge Barr.
All right,
Mr. Burgess is representing him on that case.
got it. Okay. So I don't think, he's not held on these, is he?
So he has, that was my next question. He does have $100 bonds on each. It may be 1,000%, but it actually says $100 on each. He is going to be requesting a personal bond on Tuesday before Judge Barr. That case is reduced to a misdemeanor. So we would like to request this court to reduce these cases to personal bonds as well.
Are the people gonna have any objection to that?
No, Your Honor.
I'll adjourn these cases to April 23rd, 2025, 9 AM. Okay. Then and I'll set his bonds in these cases as personal recognizance, $5,000 bond. And I'll just do that now. And then if he gets that other PR, then we'll be all set.
Thank you.
All right. Thank you, sir. Exactly. Let's call the case, People versus Elijah Kyler.
Absolutely. People are better. Elijah Kyler in both matters, who appears via Zoom on our DOC. Sir, can you please state your name for the court?
Elijah Kyler.
Okay.
Judge, we have reached a resolution in these cases.
Yes.
The defendant is going to be pleading to the misdemeanor case 2211408 as charged with no contest plea. In exchange for that, the felony case 22F55145 will be dismissed as long as the defendant agrees to pay restitution. I'm so sorry. To protect it from predator. I'm sorry about that.
Right.
So we'll be pleading to be misdemeanor and dismissing the felony case as long as we agree to pay restitution to the Ann Arbor Police Department for the vehicle that was damaged. That is correct, Your Honor, and I have discussed that offer with my client. He would like to accept that at this time. We did no contest to the misdemeanor charge in the misdemeanor case, and we do understand that there is an agreement for him to pay all restitution. That amount is not yet set.
Okay. So just so that I'm clear as to the mechanics of this, you want the restitution from the felony to be assessed in the misdemeanor case?
Yes, please, Your Honor.
All right.
If the court will be willing to do that.
Yeah, I'm not gonna have a problem doing that. Very good. Okay. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name for the record, please.
Elijah James Kyler.
Okay, you can put your hand down. Sir, it is this court's understanding that you are going to plead no contest to the charge of malicious use of a telecommunication service.
Yes, Your Honor.
That is a misdemeanor punishable by up to 6 months incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, I do, Your Honor.
All right. Two things I need you to understand about it. It first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Such a civil liability, Your Honor.
All right. So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, I do, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, I do.
You understand you're giving up your right to appeal upright.
Yes, I do, Your Honor.
Are you on probation or parole?
I'll be on parole this summer.
Okay, but right now you're not on probation and you're not on parole.
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case 22-9307. Any objection to the court reviewing that report?
No, Your Honor. No.
Court, on the review of that report, does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the defense counsel. Have I complied with the court rule?
You are satisfied. Yes, Your Honor.
All right. Court will accept the defendant's plea of no contest to this charge. And 22 F5-1545 is dismissed as part of this plea agreement with restitution being reserved and assessed in the other matter. So the determination of restitution is just needs to be gotten from APD. Is
That's
that
my intent, is to get that number from them and pass on to Ms. Valero.
all right? So defendant is referred to probation for pre-sentence investigation and report and determination of restitution. Sentencing in this matter will be
April 30th at 12 p.m.
April 30th, 2025, 12 p.m. All right. His bond will continue in this matter. Sir, I need you to hold on the line. We're going to put you into a breakout room with our probation intake so they can get preliminary information and get the process started, okay?
Okay, thank you, Your Honor.
All right.
Just have a great
Thank you,
afternoon.
sir.
Thank you, Your Honor. Thank you, Mr. Kyler.
Thank you.
Got it. The people versus Kia Berry.
Evidence over on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with on behalf of Ms. Berry, who should be present via Zoom. Can you please unmute and state your name for the record, ma'am?
My name is Kia Berry.
Jeez, you got her. Okay. All right, what are we doing?
Thank you, Your Honor. So since we've been last in court, Ms. Berry did take a written test. Again, she is scheduled to take it again this Friday. She is very hopeful and expects to pass this Friday and is asking for another adjournment
Sometime what?
into May.
Only during the matter. Objection, May 7th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Ms. Berry.
Thank you.
Court calls case people versus Daniel Bowe.
Evidence over on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and possibly or definitely on behalf and hopefully with Mr. Bowe, maybe present via Zoom.
So Mr. Bowe is in custody at Macomb County Jail?
Yes.
Yes, a writ was done, but we didn't get the confirmation of it. So they signed in at 9 a.m. this morning, but we're not able to accommodate the 11 a.m. time clock.
They signed it. Oh,
yeah. But we didn't know until after they had left.
Okay.
So Macomb County was with us.
So that would be his explanation for his failure to thank you that information. I did not know he was in the Cook County.
This is very articulately put. I'll adjourn this to April 23rd, 2025, 9 a.m. Thank you.
Are we gonna need another written?
Yes, we are.
Thank you.
Court does call the case People versus Micaiah Burton.
County of Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Tate with the County Action Court. This present in Zoom. Ma'am, can you please unmute and state your name for the court?
Good morning. My name is Micah Burton.
It's Micah. Okay.
Thank you, Your Honor. There is a resolution in this matter to which my client will be pleading guilty under HIA.
And Your Honor, given her age, that requires a consent of the prosecution, and I have given that consent.
Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes,
State your name for the record, please, again.
Micah Burton.
All right. Remember, this is court's understanding that you're going to be pleading guilty to the charge of retail fraud under the Pittsfield Township Ordinance. That's a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent and not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything to get you to plead to this charge other than what's been stated here today on the record?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes.
On the date of January 14, 2025, at the location of 7000 East Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, what did you do at the Walmart that makes you think that you're guilty?
I skip scanned items at the Walmart and I tried to leave without paying for them.
All right. The store was open to the public at the time?
Yes.
You didn't have anybody's permission to not pay for these items, did you?
No.
And these items that you skip scanned, they were items that Walmart had offered for sale? I didn't hear your response, ma'am.
Yes, Your Honor.
Yeah, okay. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing will be
30th, 12 p.m.
April 30th, 2025, 12 noon. All right. Defendant's bond will continue. All right. And ma'am, I need you to wait on the line. We're going to put you into a breakout room with our probation intake so we can start that process. Okay.
Okay. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Ms. Burton.
Court calls the case People versus Keisha Bush.
County of Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Tate with County Action Bush, who is presently in Zoom. Ma'am, can you please unmute and state your name for the court?
Keisha Crystal Bush.
All right. What are we doing?
Thank you, Your Honor. There is a resolution in this matter, to which my client will be pleading no contest to count 1 under the prosecutor's deferred, and count 2 will be dismissed.
That is correct.
Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name for the record.
Keisha Crystal Bush.
All right, you can put your hand down.
Thank
Ma'am,
you,
it
Your
is this
Honor.
court's understanding that you're going to be pleading no contest to the charge of retail fraud under the Pittsfield Township ordinance. That's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes, Your Honor.
Basis or
Sorry.
no contest plea?
Potential civil liability.
Ma'am, do you understand what a no contest plea is?
Yes, Your Honor.
All right, two things about it. I have to make sure that you understand it. First means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal upright.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-1599. Any objection to the court having reviewed that report?
No, Your Honor. Sorry.
Thank you, ma'am. All right.
Sorry.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
The court will accept the defendant's plea of guilty to, or plea of no contest to count one. Count two is dismissed. Defendant is referred to probation for pre-sentence investigation and report and determination of prosecutor's deferred sentencing. Sentencing in this matter will be April 30th.
Both, yeah.
Open a whole new world of fascinating places.
$12 p.m. All right. Bond in this matter will continue. Ma'am, I'll need you to hang on the line. We're going to put you into a breakout room with probation intake so they can begin the sentencing process, okay?
Okay, yes, Your Honor. Can I say one thing? I've seen you on TV and I just love how you carry yourself and you're an amazing judge. So I appreciate your time today.
Well, thank you very much for those kind words, ma'am. Much
You're very
appreciated.
welcome. Of course. Have a good day.
You too. I told you, Alan. No. Court calls the case Brewer versus James Church.
Good
morning, this is Nicole. Good morning. The church. Please say your name.
James Church. Morning.
Morning.
First time I'm meeting Mr. Church. The number we had for him was not serviced. So now he's here, I'm gonna get a good number. And I ask for the adjournment of the pre-trial, please.
I'll adjourn the pre-trial without objection, April 23rd, 2025, 9 a.m. His bond will continue. Thank you, Mr. Church. Court calls case People versus Devin Collins.
Conrad Silver on behalf of Pittsfield Township.
It's always better than
Thank you.
Mr. Collins, should be present via Zoom. Mr. Collins, are you on Zoom?
It's very cool.
I know it was. Mr. Collins, Mr. Collins.
So, Your Honor, I don't have an explanation for failure to appear. He's always been really communicative with me. I wasn't able to get a hold of the hearing well, which was unusual. So I don't have an explanation for failure to appear. I would request adjournment.
bench warrant release for defendant's failure to appear. Bond $5,000. I'll give a 10% privilege. Because of its previous 4 warrants, this warrant will issue immediately.
Thank you.
Thank you.
So that's what happens when you don't call. If you have a summons to come to court and be in court on a certain day at a certain time and you don't show up, that judge is going to issue a bench warrant for your arrest. I don't understand why. Well, you know, I don't want to talk about that other garbage. A lot of them, they need to go to jail. That's all there is to it. Well, you know what, everybody? That is it for today. Tomorrow is Judge Boyd. Thursday is Thanksgiving, and I'm taking off. I'm not going to do a live stream. I stream every day at 3 o'clock p.m. Central Time, 4 o'clock Eastern Time. If you like the content that's on this channel, and you're not a subscriber to this channel, please do me a big, huge favor of subscribing to this channel and letting this channel grow. That's it for today. Ta-ta, ciao. Have a good rest of your evening, and I'll see you guys tomorrow.
solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's okay.